are given. Today, we will discuss about the special provisions which are given to the Union Territory of Delhi. The 69th Constitutional Amendment Act of 1991, with effect from 1 February 1992, provided a special status to the Union Territory of Delhi. It also redesignated it the National Capital Territory of Delhi and designated the Administrator of Delhi as a Lieutenant Governor. It created a Legislative Assembly and a Council of Ministers for Delhi. The strength of the Legislative Assembly is fixed at 70 members directly elected by the people. The elections are conducted by the Election Commission of India. The Assembly can make laws on all the matters of the state list and the concurrent list except the three matters of the state list, that is public order, police and land. But the laws of Parliament prevail over these made by the Assembly. The strength of the Council of Ministers is fixed at 10% of the total strength of the Assembly, that is 7, which contain 1 Chief Minister and 6 other ministers. The Chief Minister is appointed by the President and not by the Lieutenant Governor. The other ministers are appointed by the President on the advice of Chief Minister. The Minister hold office during the pleasure of the President. The Council of Ministers is collectively responsible to the Assembly. The Council of Ministers, headed by the Chief Minister, aid and advise the Lieutenant Governor in the exercise of his or her functions, except in so far as he or she is required to act in his or her discretion. In case of difference of opinion between the Lieutenant Governor and his or her ministers, the Lieutenant Governor is to refer the matter to the President for decision and act accordingly. When a situation arises in which the administration of the territory cannot be carried on in accordance with the above provisions, the President can suspend their operation and make the necessary incidental or consequential provisions for administering the territory. In brief, in case of failure of constitutional machinery, the President can impose his or her rule in the territory. This can be done on the report of the Lieutenant Governor or otherwise. This provision resembles Article 356, which deals with the imposition of President's rule in the states. The Lieutenant Governor is empowered to promulgate ordinances during the recess of the Assembly. An ordinance has the same force as an act of the Assembly. Every such ordinance must be approved by the Assembly within 6 weeks from its reassembly. He can also withdraw an ordinance at any time, but he cannot promulgate an ordinance when the Assembly is dissolved or suspended. Further, no such ordinance can be promulgated or withdrawn without the prior permission of the President. Thank you and have a nice day.